You entered the exclusion zone on 7/8 at 9:08 a.m. You left at 9:13, entered again at 3:57 a.m.
A defendant violates his bond conditions not once, not twice, but 6 times in 45 minutes. And his excuse? Hurricane Beryl. Today, we're diving into a case that puts the justice system in an impossible position. Do you jail someone for seeking shelter during a natural disaster, or do you let a serial violator walk free? We've got GPS data showing late-night trips to forbidden zones, a defense attorney realizing mid-hearing that the exclusion order might have been a mistake, a judge comparing his own hurricane struggles to the defendant's desperation, and a shocking revelation about why this address was restricted in the first place. From weapons charges involving an AR pistol to a mother and sister who might hold the key to this entire case. Buckle up, because this courtroom is about to deliver one of the most emotionally charged bond violation hearings you've ever seen. Let's get into it.
There was a curfew in this case, was there not?
Yes, and if you would, Judge, if you're anything like me, you have a tank of goodwill that can run empty. And you've given us more than we deserve in this case. Hurricane Beryl, this was the height of when Hurricane Beryl was coming through the neighborhood.
Who in their right mind is supposed to be out in a hurricane at 4 a.m?
His power had gone out. He learned that his sister had a generator. And so that's where he was, that's the address. It's his sister's home where there was a generator that could provide some cool air. And that's what was happening in this case. But there's no excuse. He understands what his bond conditions was.
Let me ask you this. Was he allowed to be at the house that he went to?
Not according to his bond.
I had nowhere to go. It's hot.
So what? Everybody else in Houston still doesn't have power. 1 million people still don't have power. Still, to this very moment. And they're dealing with it.
Hold on. Let's break down what's really happening here, because this is where the case gets complicated. The defense attorney is painting a sympathetic picture. His client's power went out during Hurricane Beryl. He has a sister with a generator, and he went there for relief from the brutal Houston heat. Sounds reasonable, right? But here's the kicker. The judge just dropped a truth bomb that cuts through all the sympathy. 1 million people still don't have power to this very moment, and they're dealing with it. That's the legal reality check. Yes, the defendant was suffering. Yes, the circumstances were extreme. But so were the circumstances for 1 million other Houstonians, and they didn't violate court orders to find comfort. This is a fundamental tension in bond violation cases. Do extraordinary circumstances justify breaking the rules, or does making exceptions undermine the entire system? The judge is clearly leaning toward the latter, and you can hear the frustration building. The defendant had bond conditions, knew about them, and violated them anyway. The defense is asking for mercy based on a natural disaster, but the prosecution and the judge are about to remind everyone that rules don't pause for hurricanes. So here's the question for you. If you were in the defendant's shoes, sweating, struggling to breathe, with no power and a sister offering refuge, would you have risked a violation? Drop your thoughts in the comments.
Did you contact pretrial services to let them know where you were going?
Yes.
When did you do that?
Yesterday.
Okay, but you didn't do it before you went.
I called them. They wasn't answering the phone. I got pictures.
I don't care about
screenshots.
calling Jesus.
Yeah.
It don't matter who you're calling and what's your excuse. You have bond conditions. This is not the first time. This is not the second time. This is not the third time that you've had bond violations. How many is
This
this?
is the 6th time I've been here in the past 45 days.
Wait. 6 violations in 45 minutes. That's not a typo. The judge just revealed that this defendant has racked up 6 separate bond violations in less than an hour of court proceedings. Let that sink in. This isn't some one-time mistake during a crisis. This is a pattern of repeated non-compliance that stretched the court's patience to the breaking point. The defendant tries to justify himself by saying he called pretrial services, but they didn't answer, and he even has pictures to prove it. But the judge's response is ice cold. It don't matter who you're calling and what's your excuse. You have bond conditions. And that's the heart of the issue. Bond conditions aren't suggestions. They're court orders backed by the threat of incarceration. When you're released on bond, you're essentially promising the court that you'll follow specific rules in exchange for staying out of jail while your case is pending. Violating those conditions once might be understandable. Twice might warrant a stern warning. But 6 times? That's a pattern that screams either complete disregard for the court's authority or an inability to comply with basic supervision requirements. Either way, it's a massive problem. And here's what makes this even more dramatic. The judge has to decide right now whether to revoke bond and send this guy to jail, or give him yet another chance despite the mounting evidence that he won't comply. What would you do if you were the judge?
Am I supposed to let you go after 6 times? Mr. Stewart.
To be fair, the first time was my first appearance, so that was just a regular court thing.
You know, we all have to deal with very stressful situations. We are all under, we all deal with the stress. And really, 1 million people still, or I'm got to imagine it's hopefully less now,
I
but
still don't have lights.
so many other people don't.
Sure.
But that doesn't give you the right to go where you're not supposed to go. And not only have I ordered you not to be out in the middle of the night, but the police and everybody else told you, stay at home. Don't go out in a hurricane. And yet you go out. It's not goodwill. You know, I mean, Mr. Mercer, now it becomes enabling. That's what it does. And it tells him that if I let him go, it's okay. It's not. He still thinks he can do whatever he wants to do.
This is where the judge lays down the law, and his reasoning is absolutely critical to understanding why courts take bond violations so seriously. He says, it now becomes enabling. It tells him that if I let him go, it's okay. It's not. He still thinks he can do whatever he wants to do. That's not just judicial frustration. That's a statement about accountability and the psychology of compliance. If the court keeps excusing violations, even sympathetic ones, the defendant learns that the conditions are negotiable, that there's always a loophole, that a good story can get you out of consequences. And that's dangerous, not just for this case, but for the entire pretrial supervision system. The judge also makes a devastating point. Not only have I ordered you not to be out in the middle of the night, but the police and everybody else told you to stay at home. Don't go out in a hurricane. And yet you go out. So the defendant wasn't just violating court-imposed conditions. He was also ignoring citywide emergency directives designed to keep people safe during the storm. That actually undermines his defense that he was acting out of necessity for his safety. If conditions were so dangerous that authorities were telling everyone to shelter in place, why was he traveling at 4 a.m.? The defense attorney tries to push back, but you can tell the judge is reaching the end of his patience. This isn't about being heartless. It's about maintaining the integrity of the system.
I'm tired of coming in here and making excuses. What I've had to do is to remind myself.
Look, if you want to withdraw from that case, you can withdraw and I'll appoint him a lawyer today. I'm not letting you go. It's not fair.
Go, Judge. I got asthma and allergies. I'm literally sweating bad. I couldn't even breathe in the house, Judge. I could not.
Stay.
No, I can't go nowhere else. I'm steady. I'm looking for a job. I can't find a job. It's hard. Everything is hard for me. Like literally everything is hard, Your Honor. Like
I didn't have power either. I don't have air conditioning. I have a fish that I'm trying to save by sitting there bubbling water myself, trying to keep this fish alive.
I don't have.
So we all have things that we deal with.
No, nothing. You want to like, I can't even charge. I barely can charge my ankle monitor. We have no power, like literally no power.
Go somewhere else. You don't go to the house that you're forbidden.
I don't have literally, I don't have nowhere else to go. I don't have family out here. I only have one person out here, one other person out here, other than my mom. Literally.
This moment right here is absolutely heartbreaking, and it's where you see the human side of the justice system colliding with its rigid rules. The defendant is pleading, literally begging, explaining that he has asthma and allergies, that he couldn't breathe in the sweltering heat without power, that he's struggling to find work, that everything in his life is hard. And then the judge delivers one of the most memorable lines of the hearing. I didn't have power either. I don't have air conditioning. I have a fish that I'm trying to save by sitting there bubbling water myself, trying to keep this fish alive. It's almost darkly comedic, the judge comparing his struggle to keep a fish alive to the defendant's struggle to breathe. But it's also profoundly human. The judge is saying, I get it. I was there too. We all suffered. But I didn't violate any legal obligations, and neither can you. The defendant's response that he can barely charge my ankle monitor because there's no power actually raises an interesting legal dilemma. If you're required to keep a GPS monitor charged, but you have no electricity to charge it, what are you supposed to do? Go in a location with power makes practical sense. But if that location is forbidden, you're stuck between two violations. The judge's solution: go somewhere else. Assumes the defendant has options, but the defendant insists he literally has no other family or support in Houston besides his mom and sister. And that's about to become a critical point.
Judge, I'm not sure why the address was an exclusion zone. There's no victim in the case. It was an unlawful carry case. I don't know. If I would have caught that, I would have asked the judge to amend that order because it's his mother's and sister's house, and there was no reason to have that on the bond conditions. I don't understand why that was.
Tell me about it, because I don't remember. It's now been so many cases and so much that I don't even remember anymore.
On the first page, Judge,
I don't know, which case are we, because there's,
the weapon case, so
Okay.
it's March 12, 2024, officers were conducting a fugitive investigation for a wanted fugitive when they observed the defendant standing in front of an apartment in Harris County, Texas, with an AR pistol on his waistband. Rifle magazine was visible on the right side of his waist. Officers approached the defendant and instructed the defendant to come to them for their investigation. The defendant then turned and ran away 20 feet from outside to inside of his apartment and ran upstairs with the firearm still in his possession. Officers then surrounded the apartment and gave commands for the defendant to come outside, which he eventually complied with. Officers then obtained consent from the homeowner to search the apartment and located an upper receiver inside a dresser, the rifle magazine inside the dresser, and a lower receiver of the rifle in another dresser near the window. The upper receiver had a live 300 blackout round ejecting out of it.
that's the first case.
That's the first transaction. He picked up evading and unlawful carrying in a public place. The other two were evadings.
So
That's where the exclusion zone came from.
And here is the game changer. The defense attorney just realized, apparently for the first time, that the exclusion zone might have been a mistake. He admits, I feel like I dropped the ball on that because I would have asked the court to amend it. It's his mother's and sister's home, and I didn't feel like that was necessary for him to have. Let's unpack what this means. The underlying case involves serious weapons charges. Police conducting a fugitive investigation observed the defendant with an AR pistol in his waistband. When they approached, he ran into his apartment with the weapon, leading to charges of evading arrest and unlawful carry. But here's the critical point. There's no victim in this case. It's not a domestic violence situation, not a stalking case, not a scenario where someone needs protection from the defendant. So why was his mother and sister's home designated as an exclusion zone? The prosecution even admits they didn't request it because there was no victim. This suggests the restriction might have been imposed as a blanket condition without proper justification. And if the exclusion zone was inappropriate from the start, that fundamentally changes how we should view the violation. The defendant wasn't deliberately defying a protective order meant to keep someone safe. He was going to his family's home, which arguably should never have been off limits in the first place. The defense attorney is basically admitting malpractice here. He should have caught this and challenged it before violations occurred. But now the question is, does that change the judge's analysis?
I feel like I dropped the ball on that because I would have asked the court to amend that. It's his mother's and sister's home, and I didn't feel like that was necessary for him to have it.
Why did we do that in the first place, the exclusion over there? Do you know?
Judge, I don't believe it's something we requested because we didn't really rip anybody since there wasn't a victim in the case.
But your mother and your sister stayed in?
Yes, my sister stayed over there.
It says he shall not go to or within 500 feet of the drive.
I don't want to make a presumption, Your Honor, but I do feel like if I had approached the DA and asked them to amend that, I don't think they would have been opposed. That's something that I should have done.
And I'm with you.
If I had done that.
And Mr. Mercer, I'm with you, but he's still out at 4 a.m. You're still going out at 4 a.m.
I was leaving the place I was at because me and my mom were panicking so much. And I had to go to went to my sister's house. You can ask my mom, you can call my sister, you can literally ask both of them. They'll tell you. Literally. I was hiding. I have asthma and allergies. I can't breathe. I cannot breathe.
So bring him over here. I want to talk to him then.
I can call him on the phone, over the
They've
phone.
been texting with me. They said, please have the judge call us. So.
And she's even been calling. I promise she's even been calling here.
Bring him here. Let's talk to him Monday.
Okay.
Okay, Judge. Thank you.
Hold to Monday.
In the interim, if it's their actual address, Judge.
And there's the resolution, at least for now. Instead of making an immediate ruling, the judge does something brilliant. He hits pause. He orders the mother and sister to come to court on Monday so he can hear directly from them and verify the facts. This is excellent judging for several reasons. First, it shows the judge recognizes he doesn't have all the information he needs to make a fair decision. Second, it gives the defense attorney time to potentially amend the bond conditions and remove the exclusion zone that probably shouldn't have been there in the first place. And third, it allows emotions to cool and everyone to approach the situation with fresh perspective. But let's be clear about what just happened here. This case exposed serious flaws in how bond conditions are sometimes imposed. An exclusion zone was put in place without a clear victim protection rationale. The defense attorney failed to challenge it, and the defendant ended up facing revocation for going to his family's home during a natural disaster. At the same time, the defendant has 6 violations on record, showing a pattern that legitimately concerns the court. The judge is still troubled by the 4 a.m. curfew violation, even if the location restriction was improper. Being out in the middle of the night during a hurricane violated the time-based conditions. So where does this leave us? The defendant gets a reprieve until Monday. The exclusion zone will likely be reconsidered, and the court will make a more informed decision after hearing from the family. But the broader questions remain. Should courts make emergency exceptions to bond conditions during natural disasters? How carefully should restrictions be tailored to actual case facts rather than applied as blanket rules? And what responsibility do defense attorneys have to challenge inappropriate conditions before violations occur? These are the kinds of issues that make criminal justice so complex. There are rarely perfect answers, only difficult balancing acts between safety, fairness, and practical reality. So what do you think? Was the defendant justified in seeking shelter during the hurricane? Or should bond conditions be absolute no matter the circumstances? Should the exclusion zone have been imposed in the first place given there's no victim? And did the judge make the right call by continuing the hearing to gather more information? Drop your thoughts in the comments below. I genuinely want to hear your take on this. And if you found this case as compelling as we did, make sure to smash that like button, share this video with anyone who loves courtroom drama and legal analysis, and don't forget to subscribe to the channel for more jaw-dropping breakdowns where we dissect real cases, explain the legal complexities, and show you exactly how the justice system navigates impossible situations. We got more incredible content coming your way, and trust me, you won't want to miss it. Thanks for watching, and I'll see you in the next one.